Hello and welcome to today's webinar titled Methods to Fund Buy-Sell Agreements. I'm Rob Wellendorf. I'll be your moderator for our program today. Let me mention the powerful illustration of real collaboration as we are delivering today's program co-sponsored by the National Association of Estate Planning Councils, Planners and Councils, and the Society of Financial Services Professionals. Clearly, both organizations enjoy the synergy of multiple disciplines, being members and actively involved, and this program today will, of course, deliver that. If we look at the housekeeping just for a moment, I have a couple items for you. First and foremost, of course, the program is being recorded, and in about a week, a link will be emailed to you. If you want to access the PowerPoint presentation by PDF, there is a handouts button on your control panel that'll give you access, or you could also find the presentation by clicking on the link in your confirmation email. Regarding continuing education, for the accounting credit, you will be asked to use the CPE participation codes. There will be 2 during the program, and those codes will be required to be part of your evaluation following the program. We will have 1 professional recertification credit, the CPE credit as mentioned, and then also 1 credit for CFPs. And upon your completion in about a week, the certificates or certification will be emailed out to you as well. Regarding questions, we will have time at the end of the program for Q&A with Mr. Aussem. The last perhaps 8 or 10 minutes, I will encourage you to use the questions tab on your control panel to submit the questions. Again, we will have the questions at the end of the program. Now to our presenter, Mr. Jim Aussem, JD, AEP. Jim is a shareholder in the Cleveland law firm of Cavitch Familo Durkin, LPA, and is a member of their board of directors. He's also co-chair of the business practice group. Jim's practice is focused on succession planning, mergers and acquisitions, as well as estates and trusts. Jim has been a frequent speaker and facilitator, as well as an instructor for many professional organizations. I should also mention, I see Jim as a remarkable professional, a sincere collaborator, and I'll also consider him and call him friend. Mr. Jim Aussem.
Thank you, Rob. I really appreciate being involved. I've got a lot of good friends at FSP and NAPEC. I want to thank Patty McFadden and Shannon Griffin from FSP for putting all this together and doing all the legwork. I have the easy part. And my good friends, Eleanor Spuler and Joan McCarthy. Eleanor is now in Florida, but Joan has been a friend of mine for 40 years here in Cleveland. And of course, Sarah Butterfield, I understand, was very instrumental in getting this done. This is one of my favorite topics. And what I want to do is give you a broad brush approach. Because my whole purpose, and I use what I call the PI method of public speaking, I want to persuade you as members of FSP and NAPEC that this should be useful to your practices. I want to inform or educate you. That's the I in the PI method. And then the E in the PI method is really to entertain you, to keep you awake and interested in this project. We're only going to be about 45 minutes to 50 minutes before we stop for questions. And what I do and my approach is this. I'm going to start out, you can see from the first slide, broad brushed approach, types of buy-sell agreements. And for most of you, this first portion is going to be a review. It's going to be a review of things you've already learned, things that you use in your practice, and those sort of things. I promise you, as we get further into this, we are going to, in fact, have more detail, more granular, if you will. But we're going to start out big, put everybody on the same page, so to speak, and then as we get further into it, we'll get into more detail, if you don't mind. So clearly, the first thing is redemption, cross-purchase, and hybrid. So let's deal with the redemption. The redemption is, and we call it stock. Well, nowadays that could very well be membership interest in a limited liability company. And frankly, it's probably more commonly that nowadays. So we're going to call it entity ownership. If the redemption is an entity, in other words, it's the corporation, it's a limited liability company actually being the one obligated under the buy-sell arrangement to purchase the members, the owners, the stockholders' interest in the entity. What are the aspects of that? Well, if the entity is the purchaser, probably the remaining members, shareholders of the entity should be guarantors. Because at some point in time, that particular seller, if the seller is still alive, the transaction is not being funded by insurance, therefore the entity is the obligation. And why do banks require people to personally guarantee? Not because they want to take their homes, because they want their commitment. And when you're doing a buy-sell arrangement and you're doing it as an entity redemption, you in fact want to make sure there's a commitment. And the third thing you should remember is that if there is a redemption, it impacts the balance sheet of the buying entity, because at some point in time it's going to be obligated or it's going to use working capital to make that purchase. Cross purchase. That is pretty straightforward. Cross purchase is where if I and Rob and Shannon and Patty, I'll use the four of us, if you will, as our business group, and they have an insurance policy on me because I'm the old guy. Well, and then I have a policy on them. Well, what happens is if we have four shareholders, I own 3 policies, Rob owns 3 policies, Shannon owns 3 policies, and Patty owns 3 policies. So that gets complicated. And so we're going to get into later on how to get around all of that multiplicity of policies in a cross purchase. Now, I want to point out one thing that I occasionally run into in my practice that is a mistake quite often made by the client, not by the professional, but I'm going to bring it to your attention in case you see it. People will say, well, you know what? I already have a life insurance policy on my life. Why do we need to go out and buy a new one? So I'm just going to make Rob the beneficiary of the life insurance policy that I own of my life so that when I die, he gets the insurance proceeds and then he buys it from my family. That is a mistake. The IRS treats it as though, since I can change the beneficiary up to the moment that I die, that I have made a gift to Rob. Okay? Totally different tax treatment. The correct structure of a cross purchase is just what it means. I own a policy on Rob's life. Rob owns a policy on my life. I am not making Rob the beneficiary of a policy that I own on my own life. That's a mistake. Please be sure that you review what your clients have done, because quite often they do, in fact, make that mistake. So you probably will need to fix it. There's a basis step up when I buy Rob's shares or Rob buys my shares. And the beauty of a basis step up in a cross purchase is I received the life insurance attributable to Rob's death, income and estate tax free. I then use those proceeds to buy his stock. I could therefore get a step up in basis in the stock I acquired from Rob's estate. So I get the best of both worlds, tax-free funding, and I get a step up in basis upon the purchase. Really works well. D, who's going to pay the premium? Quite often, the practical side is the company is going to write the check and pay the premiums. But since I own the policy on Rob's life, that premium payment is going to hit my W-2 or my K-1, whatever the circumstances may be. I'm going to pay tax on that. The things you have to take into account, of course, is if there's an old guy like me and Patty's buying stock or buying a policy in me, her taxable income is going to be higher because it's going to cost a lot more to insure me. And sometimes people have to work that out as part of the detail in this type of planning. The hybrid method, just what it means. There's 2 methods here. One, stock redemption or cross purchase. So what you have is generally the surviving members of the entity, the business entity, are given the first right to acquire the stock of a decedent. And that is the case because they get the step up in basis, et cetera, et cetera, et cetera. And if one of them doesn't want to buy, then the other ones can buy in proportion to their interest in the entity. That's usually the first option. If they choose not to buy, then perhaps the entity has the mandatory obligation to buy. And the thing that I stress here is mandatory, because if somebody dies, there should be, in my opinion, in terms of buy-sell planning, an obligation of the estate to sell so it's locked in for tax purposes, and an obligation of either the shareholders, members of the LLC, or the entity. Somebody should be obligated to buy. Worst case scenario is there's funding for this transaction, and I had this experience very early in my career, where the entity was obligated to buy the stock. Upon my client's death, the surviving member of the entity convinced the widow that things were going great. She should continue to own an interest in the entity, left the insurance proceeds in the entity, and then he drove the entity into ground. She never got bought out, never got the insurance proceeds. The insurance is used for one purpose only. That's to fund the buyout. Where is the funding done? Well, clearly, if the entity owns the insurance policy because it's a redemption, then the entity is going to have to pay for the tax. And as you all recall, life insurance, unless it's Section 79 group term up to $50,000, is not tax deductible at any level. So it's a point where do you want to park that non-deductible expense? And we'll get into that later when we talk about some more of the granular analysis. This is what I like to use as the starting point when I talk to clients about buy-sell. The trigger events. If you die, are you obligated to sell? If you become disabled, what does that trigger? If you want out, what happens? And of course, discord. I used to use the term divorce. Clearly, discord's a little bit broader. Clearly, divorce is a form of discord that can have a significant impact on this kind of planning. So let's talk about death. Is the estate obligated to sell? If the estate is not obligated to sell, it's not going to be binding on the Internal Revenue Service. So that's one thing to consider. And who's going to be the buyer? Is it going to be the entity or redemption, or is it going to be the other members across purchase? And who has the first option and who is obligated? Remember, if somebody dies, there should be someone, either the surviving members or the entity, obligated to buy, particularly if there's funding. Force that funding out, make sure that funding goes to the family of the deceased member. What if the person is not insurable? Well, we're going to get into that then, right? That's going to call for installment payments, interest rates, personal guarantees, all kinds of things to make sure that that deceased member's family gets what they bargained for. The last one, I'm going to give you an example. I will occasionally get a request from a client who's got a 10-year-old son or daughter, and they want to preserve their ownership interest in the entity for that 10-year-old. I tell them that's not a problem. I am sure that your partners or your other family members will continue to pay your surviving spouse and your family your salary, bonus, and benefits until that 10-year-old becomes 25. I'm being facetious, of course. Okay? And the problem is that's not a realistic approach to any kind of business, family or otherwise. If you die, you're probably going to be obligated to sell, or in fact, you should sell so that your family gets what you're entitled to, the value of your interest in the business. Now, here's an insurance sales option for you. If you have a client who truly wants to preserve his or her ownership in the entity, tell them the only way to really make that practical is to have a boatload of insurance on their own life, so that upon their death, their family doesn't need to sell in order to survive, and that child could then eventually come into the business owning their deceased parents' interest in that business. But that's the only way it's practical from my perspective. Disability, you've got to get into what constitutes disability. If I cannot practice law anymore for Cavitch, Familo, and Durkin, my disability is going to have to trigger a buyout because I can't give anything of value. If in fact the business that I'm involved in is real estate management, and we have a real estate management company who's going to find new tenants, who's going to evict tenants, who's going to do financing, who's going to rehab the property, the only thing you probably need from me is my capital, so maybe my disability does not impact my ownership interest. Got to think that through, help your clients think that through. What will be the trigger on a disability? Should the disability be insured? We know that you can buy certainly disability insurance. I don't sell either one, disability or life, but I think I've been told that disability is more expensive than is life insurance on a per $1,000 basis. So my experience is usually that disability trigger is not fully insured under buy-sell planning. So therefore, a portion of it may be insured. And at some point in time, the company may continue to make payments to that disabled member of the organization. And it's going to be tax deductible as wage continuation if you have an agreement that says that, by the way. But at some point in time, which we're going to get into that granular thing, when do those payments start being applied to the purchase of that disabled member's stock or membership units? And obviously that has to be considered as part of the planning process. At some point there's a crossover where it goes from being a disability to continue to let them function, and it becomes a purchase to acquire their interest in the entity. Departure, and the term I sometimes describe, and I wonder whether any of you who are watching this or listening to this have experienced this. At about 4 o'clock or 5 o'clock on a Friday afternoon, it's been a real tough week. You sit down with perhaps an adult beverage and decide, maybe I want to spend the rest of my life tending bar in Key West. I don't want to do this anymore. And all of a sudden, that person wants out of the enterprise. Now, when that person became a member of that enterprise, a shareholder, a limited liability company owner, they make a basic commitment to stay till I'm 55 or 60. If they want out at 50, they want out early. Now, are we prepared to buy them out early? If we have to buy them out early, should they take a discount? Because all of a sudden they're creating a drain on the working capital of the organization. Do they get a lower interest rate? Are the installments extended because they're forcing us to buy them out early? And if you have life insurance on that person's life, can you use that life insurance as a down payment, transfer the policy, or borrow the cash surrender value? Or do you go ahead and make the payments and use the life insurance as a cost recovery? Because they will eventually, sometimes clients tell you, of course, if I die, I'll need that planning, Jim. And the emphasis there is if. Discord, clearly discord in divorce, discord, and a classic discord situation. Let's take Patty McFadden and Jim Aussem. I'm a lot older than Patty McFadden. Patty McFadden is a very aggressive person who wants to do well with this business we're in together. And she wants to borrow a lot of money, and she wants to expand, and she wants to do great things. When we go to the bank, whose net worth is the bank looking at? Patty's or mine? Probably mine because of my age. And I'm saying to the bank, and I'm therefore saying to Patty, I'm not sure I want to take the kinds of risks that Patty wants to take at her age, because if she has a mistake, she has time to recover from that mistake. I don't have time to recover from that mistake because of my age. So that's the discord. And am I in Patty's way? Am I creating an obstacle to her effective growth of that business? So we need some exit strategy. Now I say, is an exit strategy a good thing? Because some people will suggest that if I have an exit strategy, then I may get out, which has all kinds of ramifications to that business. If there is no exit strategy, does it force the parties to find common ground, some consensus that they can work under to make this thing work? Don't know. You have to explore that with your clients. But any exit strategy has to involve installments, what you're going to do with the insurance if there is any, the down payments, etc. Exit strategies are key. Now, I'm going to take a break right here for a second, because if those of you who are only listening and not watching, there's probably something on the screen you should take a look at. And Shannon told me that I could mention that and suggest to you that your participation code number 1 is buy, sell, and then we're going to keep on going. All right. Now we're going to start drilling down. We're going to start doing more of the details of what should be in these agreements and what you should look for. And frankly, what you might even want to consider if you're thinking about doing a buy-sell arrangement, a succession plan for yourself as some kind of financial service professional. And I have done some transactions in that regard. And these are the kinds of things you need to take into consideration. Non-compete. If I am selling, Patty doesn't want to fund my competition with her. So if I am selling and she's obligated to buy me out, and or the entity is obligated to buy me out, it should expect me to agree to a non-compete. If the entity is buying me out, I want the entity's members to personally guarantee my buyout, because frankly, I'm making a loan to them if they're buying me out. So I want to make sure that they're committed. I have no intention of taking their house, but I want their commitment, and commitment comes from being a personal guarantee. Hey, look forward provisions, and we'll get into that later on, is quite often common in a family business. That is where I sell the business to members of my family at what I consider a discount because they are my family. I love them and I want them to prosper. And then they take that low price I gave them and 2 years later flip the company for twice what they paid me. I'm not going to be happy with that result. So look forward provision would let me participate in that transaction as though I was still an owner, perhaps at a discounted level. I want to go ahead and make sure that if I'm the seller, that the buyers, the surviving members of the entity are motivated to pay me off, to pay off my estate, to pay off my family as soon as possible. So therefore, we build into the agreement ceilings of how much money they can take, what they can take in bonuses, benefits, etc., even pay themselves rent if they own the real estate, until they pay us off. We want them to pay us off. We want to be out of the transaction. Then they're free to do whatever they want. And anybody who tells you, well, it's really not about the money, they really want to do a good job, trust me, it's about the money. We want to limit how much money they can take until they've paid my family the money it's entitled to. We want to make sure we can see the financial statements if for no other reason, same reason any other lender would want to see the financial statements. What's going on? Is the entity doing well? Does the entity have working capital? Have they incurred more debt? Is there anything we should be aware of? To the extent that I am the selling shareholder, whether I'm alive or dead, and the entity is obligated to buy me out, and there was not sufficient life insurance to pay me in a lump sum or pay my estate in a lump sum, then that obligation is going to be on the balance sheet of the entity. If the entity has, which most do, operating lines of credit with a conventional lender, bank, etc., I am probably, or my estate or my trust is going to have to subordinate that note to that lender. And we'll get into that later on as we go, because clearly subordination can have a significant impact on my estate, my family getting paid. And clearly, if they sell the company, clearly the money that's owed to me or my estate or trust should be paid. Covenants, not compete. Of course, if I compete, then they should be able to offset the payments to me. How long? Well, it's going to be at least the length of the installments, I would think. And keep in mind, there's two things here that you should think about, which I think is very important when you're doing this kind of planning with your clients. There's a non-compete that says, I can't practice law or I can't work in the financial services industry. There's a more effective version that says, and it's called anti-piracy, that I can't call on the clients that you're buying from me that I left behind. Because that's not fair, that you're going to buy those clients from me, and then I have the right to steal them from you. I have the right to take the key lawyers that work for me on those clients and move it, and you're obligated to pay me? I don't think so. And in the financial services industry, what you're really saying is, if you're going to buy my practice over time, then I'm not going to call on that. But can I stay in the financial services industry and generate new activity that is not competitive because I'm not stealing your accounts? The answer is yes. But I also build into my agreements, go ahead and say to the departing financial service professional, I want to give you an incentive to continue to send business back to me. So I'm going to give you some kind of incentive for new business as well. But an anti-piracy would say, I can stay in the industry, I can do what I've done for 30 years, I just can't do it on the accounts I sold to you. Certainly a personal guarantee is appropriate. Whether or not you take a second mortgage or get the person's spouse's personal guarantee, I'll leave that up to you, but if you really want a guarantee that's effective, that's a way to do it. And frankly, that's what the bank would do. And at some point, you or your client, if you're accepting installments over time, you're making a loan. You're acting as a lender. How far should the look forward provision be? 3 years, 5 years is a long time. I've actually done them in family enterprises where the look forward is 10 years. And it starts out at 100%, 80, 60, 40, etc. every 12 months. Different ways to do that. Keep in mind when you're doing a look forward provision that an awful lot of the proceeds paid in a closely held business sale are consulting payments, non-compete, and other things. And that's what we call alternative purchase price. And they're that way because those consulting payments are ordinary income to the seller, but more importantly, which is why they're motivated, they are currently deductible to the buyer. Non-compete payments, not so much. They're deductible to buyers, but only over 15 years And non-compete payments have slightly different tax treatment for income tax purposes than consulting payments, because you're being paid not to work, so therefore they're not subject to Medicare, whereas consulting payments would be. Okay? And certainly the purpose of a look forward strategy is to motivate the seller that the family is not trying to take advantage of them. The covenants as to salary bonus, we've already talked about that. We really want the buyers to be motivated to pay off that note. We want to limit the ability for them to pay themselves until they've paid the estate. And they're similar to loan covenants. The bank wants to make sure it gets paid, and you or your client, as the seller, wants to make sure they get paid. So build those into your agreement. And review of financial statements. Again, it goes back to that same concept. If you're a lender, you should know what the entity that's obligated to you is doing and its financial stability. Verification of compliance, well, that they're doing what they're supposed to be doing. They're not overpaying themselves. They're not taking big bonuses. They're not paying excessive rent. They're not borrowing lots of money. Right? So you know what's going on. And certainly at some point in time, the buyer should seek confidentiality. They don't want your client or you as the seller to have access to their records in affidavit. And subordination by the selling shareholder. Clearly, this is problematic because a subordination agreement, if you haven't seen one, basically what it is saying to the party by the lender, the bank, to the subordinated holder of a note, you as the subordinated holder of that note have no legal rights to enforce that note against this obligor because we're ahead of you. We're the conventional lender. Without us, that entity is going to remain in business. Therefore, it's not going to be able to pay you anyway, pardon me. Therefore, there is consideration for your agreeing to subordinate your legal rights to us. That can be problematic. And we tell clients quite often, if you're selling a business, for example, don't take back a note because you have to subordinate it to the financing arrangements of that particular buyer. Take back an equity interest in the buyer that has the ability to appreciate in value and be part of a subsequent sale or transaction. Whereas the note has a limitation on principal and the note has an interest rate and the note will never be worth more. It can only be worth less. Covenants like this are certainly necessary and quite often, almost invariably going to be demanded by the lender if the entity is the buyer, therefore a redemption. If there's collateral, collateral is going to have to be posted. And certainly a subordination agreement limits the legal remedies of the seller. For example, the buyer may default to the seller, the member who died or became disabled or left. But as long as the buyer is obligated to the bank, the seller has no legal remedies, can't enforce their rights. Covenants, acceleration of the note if the seller's entity is sold. Clearly that should be in the deal. In other words, if you're doing a stock redemption, it doesn't matter. If you're doing a cross-purchase arrangement, it doesn't matter. The underlying asset that will generate the revenue, whether it's through a cross-purchase agreement or a redemption, is going to be the entity that ends up being sold. So that should be a trigger. Should be a covenant in that agreement that says if that entity is sold, there should be a trigger. That note becomes due. It's accelerated. Okay? Clearly, the business is the ultimate collateral, and you need to know that the buyer upon the sale, the buyer needs to know that if they're going to sell the business, which is fine, they have the right to sell it, that the note's going to be accelerated. Whether or not they have sold it during that period where the seller may actually participate in the sale, that look forward for either 3 years or 5 years, for example, remains to be seen. Now, we're going to keep drilling down, as I mentioned, to these buy-sell agreements and what's in them. What further details should you be aware of? And this is a list, which we will go through. Drag-along rights. Interesting term, right? Tag-along by minority members. Supermajority issues. Dissolution and capital calls, employment status, and ownership condition. So let's go ahead and talk about what a drag-along member is. Well, if I am the 75% owner of a company and somebody wants to buy my interest in the company, they want to buy the company, I don't want to get into an argument with the minority shareholders of my entity if I think that's a good price. So therefore, I can drag them along, kicking and screaming, and force them to sell. The only way that works effectively, because there's something called minority shareholder rights in most jurisdictions. Okay? And in this particular case, I know we are not necessarily all in Ohio. Okay? But what it means is this. If we build into our buy-sell agreement, which is what our topic is this morning, this afternoon, that there will be drag-along rights given to the majority owner. The majority owner now can force the minority owners to sell. The key is that the minority owners are going to get the identical sales treatment that the majority owner is getting. Sometimes minority owners have to take a discount because they don't have control and interest. In this particular instance, when you put together a buy-sell arrangement and you put together a drag-along right, the minority owners get the same price per share, no discount, same interest rate, same terms, everything that the majority gets. And it's important because if the majority wants to be able to sell the company, they have to be able to drag those minority shareholders along, because most buyers are not going to want to deal with a minority shareholder position. This is usually drag-along rights negotiated up front as part of the buy-sell arrangements among the shareholders. One of the things you have to be careful of is if the majority owner, if you represent a majority owner, doesn't have the right to sell the entity over the objection, kicking and screaming of the minority owners, it's going to drive down the value that they could get. Because if in fact the only thing the majority owner can do is seek a potential buyer of the business who will set a price that now the minority owners can meet, most potential purchasers don't want to be a stalking horse just to set a price and waste their time. Either want to buy it or they don't. So you have to be careful. And we suggest that when you do this buy-sell kind of planning, you put together a drag-along right, particularly if you're involved with the majority owner. If you're not involved with the majority owner, then you probably want to do something called the minority rights. Okay, a minority means that the tag-along, if in fact the majority owner finds someone, which is a little unusual, but if the majority owner finds someone who's willing to just buy their 75% interest, they don't want to buy the whole thing. Most people are going to want to buy the whole thing. Most people are not going to want to have minority shareholders, minority members of their limited liability company who may be disgruntled because they didn't get bought out. So a tag-along right is saying to the minority members of that entity, if the majority owner wants a tag-along and a drag-along right, we're going to give you, that are almost always reciprocal, you, the minority owners, a tag-along right. So if somebody comes along and wants to buy the majority owner's 75% interest in the entity, you'll be able to participate proportionately, get the same price, terms, conditions, etc., as the 75% owner. Because occasionally you've got a buyer who doesn't care if they have to have minority shareholders, but they want control of 75%. So now the minority can participate with the 75% shareholder in the transaction. It's a very useful term. I would suggest that it be discussed with your clients as part of that planning. And the key thing is the terms are identical. The minority is not taking a discount because they are a minority interest. They are receiving the same terms and conditions, price per share, etc., without discount as the controlling interest. Some of the provisions you want to put into these kinds of agreements, supermajority issues. Can the company be sold? Does it require a supermajority? Keep in mind, a supermajority means that the tail is sometimes wagging the dog. In other words, can the 10% owner prevent the company from selling? I would suggest that that's not a term your clients or you should enter into. Can a 25% owner do that? Don't know. That's something you need to explore with your clients. Can a 49% owner do that? Boy, that is something you really ought to drill down and figure out. And if, in fact, if the entity is borrowing, will personal guarantee be required? In other words, if my net worth is higher than somebody who is 25, but we're business partners, do I want to post all of my net worth to guarantee some crazy problem they want to engage in, and I don't want to risk my personal net worth. Those are the kinds of things you have to bank into an agreement of this kind. Substantive changes in the terms of the agreement. In other words, if the payment is going to be over 5 years, can it be accelerated to 3 or 10? Can we dismiss an owner? Can we dismiss an owner's children? What can we do? Capital calls, treatment as a loan. Well, the key becomes this. If the entity, the limited liability company, needs more money, and I say, fine, here's my check for $1 million, and you say, or your client says, or my business partner, I'll pick on Patty McFadden, because she's a little younger than I am, that Patty can't come up with her share of that $1 million. So the question then becomes, this is what these provisions are about, these alternative provisions. If Patty can't come up with her share that we need to do what this company needs, is Patty diluted? In other words, does her interest in the entity become less as a percentage of interest? Or is my participation, do I pay her share and we treat it as a loan? We treat it as a loan and it gets priority. So upon sale or other things, I get paid before Patty gets anything for her interest in the business, and I get a reasonable interest rate, but there is no dilution of Patty's share. Is that the appropriate way to proceed? Is it a hybrid where it's either a loan or a solution or a little bit of both? And more importantly, who gets to choose? Do I get to decide whether or not I treat it as a loan, or does Patty or the board of directors, or whom? Do I get to decide whether it's partially a loan and partially dilution of Patty's interest in our LLC going forward? These are the kinds of detailed provisions you need to discuss with your clients to think them through and use examples. Example would be, for example, if we are in fact going to buy another entity, and if in fact we need $1 million to acquire that new entity, and I, because of my age, I've accumulated a few bucks, Patty hasn't, so I am willing to put up, my 60% of that $1 million, 600,000, and Patty doesn't have it. How is it going to be treated? What's the approach? That's what these provisions are about, and we like to discuss these with the clients because clearly it's the what ifs that where it really gets granular. How's it going to impact the transaction, and where does it make a difference? Employment status. Do you have to be employed to be an owner? I clearly recommend this because if you're not pulling on the same oar, and therefore you're not pulling on the same oar if you're not employed there in a closely held business, why should you continue to own stock? You're only going to be a thorn in my side. You're going to cause me problems. Who has the right to fire me or fire Patty or fire other members of my family who may be employed? Do we need a supermajority approval of that? How is that handled? Do we need, if there's 4 shareholders, do we need 3? Do we need the supermajority, or do we need the majority of the 3 members who are not the member being fired? So if we have 4 shareholders and we want to get rid of one of the shareholders, that shareholder can't vote. So now we've got 3. Do we need approval of just 2, or do we need unanimous approval? You need to think through with your clients those kind of alternate provisions because they're critical to how this business is going to operate going forward. And what I call the trigger mechanism. Remember we talked about death, disability, departure, or discord. Those are your 4 triggers. Think that through with your clients, and how is that impacted by these kinds of things? And more importantly, how is that impacted by employment? Because one of the things we tell our clients is, if you're not pulling on the same oar, in other words, that person is no longer employed there, they're probably not going to be a good owner. They're going to be a thorn in your side. You probably want a mechanism, therefore, that ties their ownership to their employment. And therefore, if in fact their ownership ends, so should their, if their employment ends, so should their ownership. Now, I've been talking for a while, and there's something on the screen that most of you probably need to be aware of because you want credit for what I'm saying in whatever particular discipline you have. And it looks like code number 2 for those of you who are not visually seeing this is 04/01/21, which I think stands for April Fool's Day. But trust me, this is not April Fool's Day. I want you to take serious what we are saying here. I'm going to move on now. I hope you got the code. Funding mechanisms. To some of you, this might be the only reason you listen to this whole presentation, because it involves life insurance. And life insurance is clearly an element of funding, if not the key element of funding of buy-sell arrangements. Clearly, the stock redemption requires some funding. We'll talk about that. Cross-purchase, the hybrid plans, and you will clearly in your practice, if you've done it as long as me, which is probably forever, you're going to run into certain situations where somebody is either uninsurable or you can't get enough insurance because there was insurance in place when you first started the program, but now they've become uninsurable. And of course, the business has grown value-wise. Stock redemption, mechanics of stock redemption, it's the entity. The entity is obligated to buy, so therefore the entity becomes the insurance owner. The problem with the entity being the insurance owner is there's no step up in basis that gives to the surviving shareholder. The entity buys back membership interest or the share interest in the entity. However, the 2017 Tax Act eliminated the alternative minimum tax for corporations and imposed a new C corporation tax rate of 21%. Keep in mind that the new arrangement is going to, in fact, potentially, I'm going to go back to that for a second. The Biden Tax Act alternatives being proposed would move the C corporation tax rate from its current flat rate of 21% to a flat rate of 28%. Now, the thing that's important to remember here in a stock redemption arrangement and an entity purchase is that purchase of our payment of premiums on insurance is not tax deductible. Just isn't, unless it's Section 79 group term insurance. Therefore, do you want the non-deductible payment made at a 21% or 28% rate if these tax changes go through, or do you want it to be at a 37.5% the individual income tax rates? Clearly for this purpose, if you can't deduct it, you want the payment to be in the entity that has the lower tax rate. And we'll get into some of that discussion and the nuances of that later on if we have time, because I think I have six or seven more minutes to go. Cross-purchase arrangement is just that. It's where, in my case, for example, I own a policy on Shannon and on Rob and on Patty, and they own policies around the horn. Okay, so in that particular case, you have a multiplicity of policy, and usually the funding could be a headache because it's quite often the company pays all of those insurance premiums, and in fact, it's just added to the W-2s of the members. But again, multiplicity of policies can sometimes make people a little crazy. So the cross-purchase arrangement quite often uses what we call an escrow, trust, or partnership arrangement. And what that means is this. The four of us, Patty, Shannon, Rob, and myself, enter into an escrow trust arrangement, or we become an LLC partners for tax purposes. And therefore, the entity that we have agreed to owns a policy in my life, it owns a policy in Rob's life, owns a policy in Patty's life, and it owns a policy in Shannon's life. So if in fact I die, and I'm the old guy, particularly in that group, they're going to get life insurance proceeds and they're going to take my family out. And that's good. The problem is I own three policies, one in each one of their lives. When I transfer the policy that I own on Rob's life to Patty and to Shannon, that, my friends, is a transfer for value. You eliminate the transfer for value if in fact you use a partnership arrangement, because we are partners. Can't use a corporate arrangement because that's not the exception to the transfer for value rules. A partnership would be, I'm drilling down now, give me some of the details or granular parts of the things you must build into these agreements. But keep in mind, if you're going to use a cross-purchase arrangement and you eliminate the multiplicity of policies, you've got to use this arrangement. If you don't eliminate the multiplicity of policies, then you have potential transfer for value. Transfer for value is the only way, I think, that you can transfer life insurance proceeds that are normally income tax free into ordinary income. Bad result, you want to avoid if at all possible. Hybrid plans, clearly in a hybrid plan, if I die, the first option may be to the three remaining shareholders to buy my interest in proportion to their ownership. that would give them a step up in basis in my interest. The default quite often would be to the entity. If the three of them cannot agree or can't or choose not to, then the company buys me out because I want to be assured that they are going to buy my interest in the entity out so that my family is taken care of. The question that must be addressed by you as the planner is, where's the insurance going to be? Is the insurance going to be owned by the surviving members or by the entity? Or can you have insurance both places? Well, certainly if you're selling insurance, that's a good result. But will the insurance company allow you to do that? Are you over-insuring for the same obligation? Is it inappropriate? And to say nothing of the fact that how costly is it to have insurance in two different places? So you need to think that through and work with your clients. But certainly in a hybrid plan, that's an issue that is going to come up. General provisions, what we encourage people to do is, if you have life insurance, the purpose of that is to make sure that the survivor, that the decedent's surviving family is not at risk for the survivors operating the company successfully. So force the insurance out under that buy-sell agreement as the down payment being the greater of 10 or 15 or 25% of the purchase price or the available proceeds of insurance, whichever is greater, get it into the hands of the decedent's family. The balance is going to be paid in installments, and the installments must bear interest, or the IRS will impute interest. Okay. The hybrid plan, I think I went the wrong way. Let me go back. Yeah. Installments must bear interest to avoid the imputed interest rule. Now, disabled shareholder, departing shareholder, discord among the shareholders, that's puts in cause and modification, how we do that. And I have 4 minutes left to get through some of this stuff. Disabled, clearly, if you can insure that risk, you should. Keep in mind that at some point, there's a crossover point where the payments to a disabled shareholder go from being disability payments to being purchases of that person's interest in the entity. The disabled shareholder cash flow, if you have an agreement that requires it to be paid, then it's tax deductible to the entity. If you don't, it might be considered just a volunteer payment or even in fact a dividend. And depending on how you're taxed, certainly if you're an S corporation, a disproportionate could blow your S corporation election. There's a whole bunch of things to think through with how you're going to do that. And I'm going fast because I want to get to three things here before I turn it over to Rob and questions. A departing shareholder, somebody leaves. Remember we talked about death, disability, and departure. Somebody simply says, I'm done, I'm burned out. I want to go 10 bar in Key West. Fine. We're going to buy them out. How are we going to buy them out? Well, if they're forcing us to buy them out, are we going to buy them out at a discount? Are we going to use the cash surrender value of the life insurance? We're going to borrow against it? We're going to transfer the policy to them? How are we going to fund this buyout? Because this person is forcing us to buy them out, perhaps before the entity or the other shareholders, remaining shareholders, are desirous of buying them out. So you need to bake that into your agreement and your planning, what the options are and how you would address those options. And then the collateral, the applicable federal rate, if you don't put an interest rate on there, there's going to be imputed interest. You don't want to be there. And restrictions, we talked about that earlier. If in fact I'm being bought out, I want to keep Patty and Shannon and Rob's salaries down until they pay me off or pay off my estate, so they can't in fact gut the working capital of the entity. Discord among the shareholders, you can use the cash surrender value to do that if you choose to. Now, I want to address this, and this will be my final points before I turn it over to Rob. If you want to address discord among shareholders, provide as part of your planning the mandatory terms for the buyout, whether it's down payment, number of installments, interest rate, non-compete, personal guarantee, before you know who the buyer is and who the seller is. Because once somebody becomes the seller, they want a whole different set of rules than if they in fact are the buyer. So you get those rules baked into your agreement. And then what you do is you go ahead and use a push-pull mechanism. The push-pull mechanism says, I come to Rob and I say, Rob, I'm burned out. I want to get out of the business. I want you to buy me out. And I give him a price. Well, he already knows that that price, has already been number of installments, interest rate, personal guarantee, and a non-compete. So now he has some period of time after I give him that price to decide whether or not he wants to buy. Okay? So a push-pull means when I make that proposal, I don't know whether I'm selling or buying. So therefore, it eliminates the problem inherent in any buying and selling. If I'm a seller, the business is a cash cow, makes money hand over fist, you should buy me out. If I'm the buyer, I'm saying, listen, you haven't paid attention to this business for years, the equipment's obsolete, things aren't going well, I'll indemnify you under personal guarantees to the bank. See the difference? The buyer and the seller, depending on which hat you're wearing, have a total different impression. With a push-pull mechanism, you don't know which hat you're ultimately going to wear. So in fact, that option should be appropriate. The last thing is discord. The push-pull put option is the way where I go ahead and say, if I want out of the business, but I want out early, I'm going to have to, instead of, excuse me, the call is the opposite. Where Rob comes to me and wants to force me out of the business. If in fact our original arrangement said there was going to be 5 years of installments, if I am selling earlier than I want to sell, Rob's going to pay me over 3 years. If the down payment called for 10%, he's got to give me 25. If he's buying me out early, perhaps he's got to pay me a premium, and the interest rate will also be a premium. He's got to give me a guarantee and a shorter non-compete. All right, I am done because I've gone too far. I almost do, but Rob, I think you've got 8 minutes left. If you want to give me some questions, I'll be happy to address any that I can.
Okay, thank you, Jim. Yes, I'm going to take these questions in order, and if we cannot get to all of them, I'll just ask that they be forwarded to you, Jim, and perhaps you can respond directly and independently. Again, if we can't get to all of them.
Happy to.
Take you back. Thank you. I'm going to take you back to a previous slide. The trigger is death. Buy sell is either entity or cross purchase. It's not been specified. Should the heirs, spouse and or estate, etc., be part of the agreement when obligated to sell at the triggering event?
Generally, no. The shareholders enter into agreement or members of the LLC between themselves. And if it's a mandatory sale, then the estate of the deceased member or shareholder is obligated to sell. Okay? And you want that obligation because you don't want to get into negotiation with the surviving members of the shareholder who died's family.
Makes sense. Thank you. Looking at the buy-sell agreement, and specifically the trigger is disability, the disability provision. What do you see as the most common date of the valuation, since often the disability trigger is typically extended, and if that valuation is years later, it may expose the disabled owner to more risk due to execution errors by the remaining owners?
What we try to build into the agreement is a trigger date, that when the payments, wage continuation payments, let's say they are 90 days at a minimum and a year at the maximum, when that starts to be required to be converted to purchase of that disabled member's interest, that's the date, should be the trigger date of the valuation.
Okay. Makes sense. Okay, here's a situation, Jim. We have 2 successful farmers. The initial plan was that both would sell when they wanted to retire. If you fast forward and now they're both in their 70s, one wants to retire and the other wants to continue the business. They want to sell to one another. One says, no, why would I do that? What should have been done or could have been done to address this type of issue?
Well, that's where the put and call would come in. If in fact they're continuing to operate that farm together, and one of them wants to continue to operate and the other doesn't, then the other would have a put. A put requires the remaining farmer to buy out the farmer who wants to leave. So he is forcing that farmer to buy him out. Quite often you build into the put potential discounts, because if the buyer doesn't want to buy, okay, and the seller is forcing them to buy, maybe there's a 10% or 20% discount. If, however, that put is exercisable only after a date the 2 of them have agreed to, was going to be the trigger date, then potentially there is no discount. Potentially there's just the matter of what the installments are. So if you, in fact, you have the number of installments, the down payment, the personal guarantee, the interest rate, and the non-compete already in place, the only thing you're talking about is what is the value to be used for the put or the call. And we have a mechanism, I think it's discussed in the document, where you go ahead and the presentation, where you go ahead and use an appraisal method. The appraisal method is where if the two owners can't agree on the price, because the terms have already agreed to, interest rate, etc., can't agree on the price, then one of them gets an appraisal. The other one can agree to that appraisal. If he doesn't like that appraisal, the second one gets an appraisal, and you take the two appraisals. If they are within 20% of each other, you take the mean. If they're more than 20% apart, you get a third appraisal, then you average it with the one it's closest to. So you've got the whole thing baked into an agreement if you want it to be.
So the question at the end of those, the fact patterns, what could have been done to address the issue? Obviously, having an agreement in place, and then you provided now, of course, the detail. And I say that with a smile because we all know how often the business owner or owners delay things of that nature. And many times they don't feel like they have a real significant asset to even plan initially. And then we wake up older, as you had referenced being the older guy. We wake up and it's like, wow, this has value and I need to figure out how to transfer it or capture the value.
It's like when they say, well, if I die, I'll need to do that. Okay, maybe you won't.
Maybe you won't. Okay, thank you for that. I'll go to the next one here. Again, it's a scenario. We have a son-in-law and the client, they own a business 51%, 49%. Sole beneficiary of the client is the daughter. Almost need a whiteboard. Client wants to get income for life if possible. There's not enough in assets to pay a lump sum for that value. Recommended structure. Yeah, that we may need more time for that one, but
well, clearly what comes to mind would be a private annuity, where the seller father and his daughter is married to, I assume, the 49% owner, the minority owner, and the business is really the one that's going to generate the revenue to make sure Dad can retire and live the way he wants to do. And a private annuity is a promise, unfunded, unsecured, by the way, by the son-in-law to buy out his father-in-law's interest in the business. And the IRS publishes a table on what the value of the business, what those payments would be. And if in fact he lives beyond his life expectancy, son-in-law is going to pay more than he would have. If he dies early, he dies early. There's no gift element in a private annuity. That sounds to me like that could be a perfect mechanism for a private annuity.
Thank you. Okay, I'll keep moving here. In a cross purchase, do you recommend at death of the first of two shareholders the right to buy the policy that the deceased shareholder owns on the surviving shareholders?
Yes. Clearly, if the surviving shareholder is not insurable, okay, you don't want the policy to lapse. Okay, so in some fashion, get that policy. And keep in mind, I believe transfers of a policy to the insured avoid the transfer for value rule. It doesn't necessarily avoid the value of the transfer, gift, if the policy is transferred without it being purchased.
And the second question related to that is, how do you set the price? At what price for that transaction?
Well, the old days used to be, what's the interpolated terminal reserve value? That would be what's the price, the value of that policy, or the unpaid premiums, or that kind of a thing. If it's a term policy, you paid the premium today, die the next day, there's theoretically $364 of 364 days of premium. But the current thinking, and I think given our audience, might be, what's the life settlement value of that policy? Is that a more accurate measure of its value? And I can debate that either way, but that might be something to think about.
Thank you, Jim. Again, the remainder of questions that we are not able to get to, I'm going to ask that they're forwarded to you, Jim, and so that you can respond. We appreciate the questions that keep rolling in. Thank you. As a reminder, when you log out, you're going to be directed to the evaluation. And for those looking to obtain the CPE credit, you'll need to put in the participation codes that Jim had provided. And as always, we really appreciate your feedback. So please take a moment to complete that evaluation. Jim, thank you so very much. I do want to say also thank you to our audience on behalf of the National Association of Estate Planners and Counsels and the Society of Financial Service Professionals. Again, we appreciate your participation, and our conference is adjourned. Thanks again, Jim.
Thank you all.